In the early years of the American Railroad, an engineer named Nicholas Farwell was running a train for the Boston and Worcester Railroad when another employee failed to manage a switch correctly. The train left the track, Farwell was thrown down, and a wheel crushed his hand. The accident raised a question that sounds simple now. Who owed him help? The switch tender had made the immediate mistake, but he did not control the railroad. The company had hired both men, organized the work, chosen the equipment, and collected the revenue. Farwell sued the company. In 1842, the highest court in Massachusetts told him that the railroad did not have to pay. The decision became one of the foundations of American workplace law. Chief Justice Lemuel Shaw reasoned that Farwell and the switch tender were fellow servants, engaged in the same general business. By taking the job, Farwell had accepted the ordinary dangers that came with it, including the possibility that another employee might be careless. The court treated the employment relationship as a contract between people who had knowingly divided the risks. If the work was dangerous, the theory went, the worker could demand higher wages before agreeing to do it. That theory had a certain elegance in a courtroom. On an industrial job site, it bordered on fiction. A railroad engineer, mill hand, or miner rarely negotiated a private price for each exposed gear, unstable roof, dust cloud, or exhausted coworker. He accepted the job that was available, knowing someone else could replace him. Yet the law acted as though he had inspected the danger, calculated its value, and voluntarily purchased it with his own body. This was the world before modern workplace safety. The factory floor had owners, supervisors, engineers, machine builders, doctors, insurers, judges, and workers, but it had no single referee with the power to stop production simply because the system was likely to injure someone. Responsibility existed everywhere in theory and almost nowhere in practice. When an accident happened, every link in the chain had a way to point toward another. The machine manufacturer could say the equipment worked exactly as designed. The owner could say a foreman had failed to enforce instructions. The foreman could say the worker had ignored a warning. The insurer could say the policy did not cover that injury. The company doctor could ascribe the damage without deciding who caused it. The judge could ask whether the worker had assumed the risk. By the time the questions reached the injured person, the wages had stopped, the hospital bill had started, and the job might already belong to somebody else. 3 legal defenses made recovery especially difficult. The first was the fellow servant rule used against Farwell. If a coworker caused the injury, the employer could escape responsibility. The second was assumption of risk. If a danger was considered obvious or normal for the trade, the worker was said to have accepted it by remaining on the job. The third was contributory negligence. If the injured worker had contributed even slightly to the accident, some courts barred recovery entirely. Together, these doctrines created a narrow path to compensation. A worker had to prove that the employer had been negligent, that the danger had not been accepted as part of the job, that no coworker was the real cause, and that the worker himself had done nothing wrong. Industrialization made that legal structure more important because it changed the scale of danger. A farm tool could injure one person. A factory power system could expose an entire room. 19th century mills commonly transmitted energy through overhead line shafts connected to belts, pulleys, gears, and flywheels. The machinery was efficient, visible, loud, and often unguarded. Loose clothing, hair, or hand used to clear a jam could be pulled into motion faster than anyone could react. A simple guard might prevent contact, but guards cost money, complicated maintenance, and sometimes slowed production. When competition was fierce and inspections were rare, prevention could look like an expense, while an injury looked like the worker's private misfortune. The same logic reached children. Factories hired children because they were cheap, obedient, and small enough to move through crowded spaces. In textile mills, young workers tended spinning frames, replaced bobbins, swept beneath moving machinery, and reached into places designed for production rather than human hands. Reform photographer Louis Hine repeatedly found children in mills whose managers insisted they were only visiting or helping a relative. The explanation was useful because state age laws were inconsistent. Birth records were incomplete, and enforcement was weak. A child could be plainly working while everyone with authority described the scene as something else. A child's wages could mean rent or food, especially in mill towns where several members of one household worked for the same company. Reform therefore threatened family income as well as factory profit. The child stood between the machine and the household budget, carrying a risk. Workers often had to stand between cars and guide a link into place while heavy equipment moved toward them. Same problem. Before automatic couplers, workers often had to stand between cars and guide a link into place while heavy equipment moved toward them. A mistimed signal or unexpected movement could crush a hand, an arm, or a body. Railroad unions pushed for change, and in 1893, Congress passed the Safety Appliance Act, requiring automatic couplers and other equipment on interstate railroads. It was an early example of the federal government treating a specific workplace hazard as something that could be prohibited before the injury occurred. But the law applied to interstate railroads, not to every mill, mine, construction site, warehouse, or farm. Most regulation remained a state matter, and states competed for industry. Legislators were warned that expensive rules would drive factories elsewhere. Inspectors often lack the staff and authority to visit more than a fraction of workplaces. Safety remained a patchwork of local commands, voluntary practices, and public outrage after disasters. Massachusetts took an important step in 1877 when it passed the country's first factory inspection law, requiring machinery safeguards and protections involving elevators and fire exits. Other states followed. Yet inspectors often covered large territories. Employers might receive notice, and courts could read statutes narrowly. Where no rule named a hazard, the old question returned. Had the worker simply accepted the danger? Mines made the limits even clearer. Underground, the employer controlled the ventilation, explosives, roof support, lamps, rescue equipment, and pace of extraction. The miner controlled very little beyond the immediate movement of his own tools. But when a roof fell or gas ignited, the disaster could be described as an unavoidable feature of mining. In December of 1907, an explosion tore through 2 mines at Monongah, West Virginia. At least 362 men and boys were killed according to the official count, though later researchers have questioned whether unrecorded workers made the true total higher. The exact ignition source was never established with certainty. Monongah was not an isolated industrial accident. That year saw a terrible concentration of mine disasters across the country. Public anger helped push the federal government toward research, and in 1910, Congress created the Bureau of Mines. But the early Bureau was primarily an investigative and scientific body. It studied explosions, tested equipment, and promoted safer methods. It did not yet function as a national police force capable of entering every mine, ordering hazards corrected, and punishing any operator that refused. Mining companies often employed doctors because remote coal camps had little other medical care, and miners commonly financed the service through payroll deductions. The system could save lives, but it placed the physician inside the same chain of control as the mine, the house, the store, and the job. The doctor might treat a broken leg while still facing questions about when the worker should return and whether an illness had been caused by the mine. Medical care existed, but medical independence was not guaranteed. The slow diseases of industry were even easier to deny than sudden injuries. A severed hand clearly followed a machine accident. Lead poisoning, lung disease, nerve damage, hearing loss, and chemical exposure could develop over months or years. A worker might leave one employer before symptoms became severe. A company could blame alcohol, age, infection, or personal weakness. The worker had to prove a connection that medicine itself was still learning to identify. Alice Hamilton helped change that understanding. Beginning in the early 20th century, she investigated lead smelters, battery plants, and other dangerous... But as a federal investigator, she often depended on persuasion to gain access. Patterns of illness, and showed that disease could be built into an industrial process just as predictably as an exposed gear could catch a sleeve. But as a federal investigator, she often depended on persuasion to gain access. She could document danger and embarrass an employer. She could not always compel the employer to remove it. One of the most revealing investigations came from the Pittsburgh Survey of 1907 and 1908. Reformers examined life and work in one of the most heavily industrialized regions in the country. Crystal Eastman studied industrial accidents and followed the economic consequences into workers' homes. The central finding was not merely that factories were dangerous, it was that the injured worker and his family usually carried the financial loss. Even when the organization of work had made the accident foreseeable, imagine the chain after a steelworker lost a hand. The mill lost part of a shift and could hire another man. The machine remained in service. The foreman wrote a report. A charity might provide temporary groceries. A wife or older child might enter paid work. Rent still came due. The injured man could sue, but the case required money, witnesses, time, and a legal theory strong enough to survive the three defenses. The accident was produced inside a large industrial system, but its cost was delivered to one household. Workers' compensation emerged to reverse that arrangement by treating industrial accidents as a predictable cost of production rather than a series of personal lawsuits. Employers would finance insurance. Injured workers would receive medical care and partial wage replacement without proving negligence, while usually surrendering the right to sue for full damages. It was a bargain designed to make payment faster and less dependent on courtroom luck. The transition was not smooth. In 1910, New York created a compulsory compensation law for certain hazardous occupations. Earl Ives, a railway switchman, was injured only days after the law took effect and sought payment. The South Buffalo Railway refused, arguing that the state could not force an employer to pay without proof of fault. In March of 1911, New York's highest court agreed and struck the law down. The decision treated compulsory compensation as an unconstitutional taking of property. The timing was extraordinary. The next day, fire broke out at the Triangle Shirtwaist Factory in Manhattan. The factory occupied the upper floors of a building crowded with tables, cloth machines, and mostly young immigrant workers. The fire spread rapidly. Some exits were locked or blocked. The fire escape failed. Fire department ladders could not reach the highest occupied floors. 146 people died. Triangle did not invent the idea of workplace reform, and no single tragedy transformed the entire country. But it exposed the weakness of a system that waited for individual workers to prove negligence after the fact. New York created a factory investigating commission and passed stronger rules on exits, fire protection, sanitation, and factory conditions. Frances Perkins, who witnessed the aftermath from the street, carried the lesson into a career that would eventually take her to the United States Department of Labor. Other states found legal paths around the obstacles. In 1911, Wisconsin established the first durable state workers' compensation system. Within a decade, most states had adopted some form of compensation. The reform changed the chain of responsibility. The worker no longer had to prove that the owner had personally caused the accident. The employer or insurer had to pay defined benefits when an injury arose out of the job. But compensation could hide the difference between paying for injury and preventing it. Benefits were limited. Occupational diseases were often excluded or difficult to prove, and many workers fell outside coverage. Employers gained protection from large civil verdicts. The system placed a price on injury, but a price was not the same thing as a guard, ventilation, or an enforceable right to refuse dangerous work. Unions, therefore, demanded more than compensation. They pushed for shorter hours, better equipment, ventilation, fire exits, trained crews, and worker participation in safety decisions. Railroad brotherhoods supported automatic couplers. Miners demanded inspection and rescue standards. Garment unions challenged locked doors and crowded floors. Yet organizing carried its own danger. A worker could be fired or blacklisted, and in a company town, losing the job could also mean losing the house, doctor, and store credit. The federal government entered the field piece by piece. It created compensation for certain federal employees in 1908. After investigations exposed the disease known as phosphorus necrosis of the jaw, Congress used a prohibitive tax in 1912 to drive white phosphorus matches from the market. The Department of Labor followed in 1913, and Francis Perkins created a Bureau of Labor Standards in 1934 to promote safety and help states strengthen their programs. New Deal laws extended federal leverage without creating one universal safety code. The Walsh-Healey Public Contracts Act of 1936 allowed the government to require labor and safety standards from companies selling goods to the federal government. The Fair Labor Standards Act of 1938 restricted oppressive child labor and allowed the Labor Department to bar minors from especially dangerous occupations. These measures mattered, but coverage depended on the kind of worker, the industry, the contract, and the constitutional power being used. By the middle of the 20th century, the United States had many safety systems and no complete one. States had factory laws, mine laws, fire codes, compensation boards, and inspectors. Insurers advised employers on loss prevention. Companies created safety departments. Unions negotiated protective language, and federal agencies regulated selected industries. Yet a worker's protection could change by crossing a state line or moving into another legal category. The hazards were changing as well. Modern industry added solvents, synthetic chemicals, radiation, and processes whose effects might remain hidden for decades. A broken ladder could be photographed. A cancer caused by exposure years earlier was harder to trace. The old model of waiting for an accident report was badly suited to diseases that developed silently. In 1960, the Labor Department began enforcing federal safety standards for longshore and harbor work. It also made safety requirements mandatory for many federal contractors. These programs showed that federal standards could reduce injuries in covered sectors. But they also showed the central weakness of the patchwork. The government could enforce a rule on a dock or in a plant holding a federal contract, while workers performing similar tasks elsewhere remained under different standards. Disaster continued to drive legislation. In November of 1968, an explosion struck the Farmington No. 9 coal mine in West Virginia. 99 miners were underground, 21 escaped, and 78 died. The cause was never conclusively determined. The disaster helped produce the Federal Coal Mine Health and Safety Act of 1969, which gave the federal government stronger inspection and enforcement authority in coal mines, and addressed health hazards as well as immediate accidents. The broader question could no longer be avoided. Why should a worker's right to basic protection depend on whether the job involved a railroad, a federal contract, a particular state, or a recent disaster large enough to reach the newspapers? By the late 1960s, Americans were working inside a national economy. Products crossed state lines, corporations operated across the country, and industrial hazards did not stop at a border. Yet the legal duty to prevent those hazards remained fragmented. On December 29, 1970, President Richard Nixon signed the Occupational Safety and Health Act. The law authorized the federal government to set and enforce safety and health standards for most private sector workplaces affecting interstate commerce. It created the Occupational Safety and Health Administration to inspect and enforce, the National Institute for Occupational Safety and Health to research hazards, and an independent commission to review contested cases. The change was larger than a new agency. The old system asked what was owed after a worker proved negligence. The new system imposed duties before the accident. Employers had to follow specific standards and provide workplaces free from recognized serious hazards. Inspectors could enter, citations could be issued, and penalties could follow. A worker no longer had to lose a hand before an exposed machine became a public concern. That was the moment workplace safety became, in principle, an enforceable public obligation across much of the American economy. It did not eliminate workers' compensation, private lawsuits, union contracts, state laws, or industry-specific regulation. It added something that had been missing from Farwell's world, a referee empowered to look at the conditions of work itself rather than waiting for an injured person to carry the entire case. But the referee was never everywhere. The law excluded some categories of workers and left others under separate federal systems. State and local public employees were not automatically covered unless a state-operated and approved plan. Enforcement depended on budgets. The deeper transformation was not the end of danger. It was the end of the legal assumption that danger belonged naturally to the person who accepted a wage. Disease remained difficult to measure. Temporary workers, migrants, and people afraid of retaliation could still remain silent. Employers could contest citations for years, and workers' compensation still exchanged the possibility of a larger lawsuit for limited scheduled benefits. The deeper transformation was not the end of danger. It was the end of the legal assumption that danger belonged naturally to the person who accepted a wage. From the fellow servant rule to workers' compensation, from state factory inspectors to federal standards, the burden moved slowly away from the injured body and toward the system that designed the work. Farwell's crushed hand had once been treated as the price of his private bargain with the railroad. More than a century later, the law finally recognized a different principle. A machine, a production schedule, a ventilation plan, a locked door, and an untrained crew were not acts of nature. They were decisions. And if decisions created predictable danger, responsibility could no longer disappear simply because every person in the chain pointed at someone else.